Actually, I thought this afternoon we'll talk about tax issues a little bit and single claimant issues, and I want to follow up on some questions that I heard at lunch as well. I said this, actually I didn't say this morning, and it's probably in many ways the most important thing that defendants want to know if anybody is working with defendants, and that is, when do they get their tax deduction? I should have said this at the very outset this morning, because that is really, apart from everything we're saying today, the only reason that these entities exist is because of this tax issue, which is the tax deductibility to the defendant. All of you aren't, lucky for you, are not tax lawyers, but a fundamental concept in the tax law is that you only get a deduction when you economically perform. And generally speaking, that means if, as you can well imagine, most of the kinds of disputes that we as lawyers, as settlement professionals see involve a business. Not all of them, but most of them. And obviously if you're looking at an auto accident case or something like that, it may or may not be an auto accident that's related to a trade or business. It may just be somebody driving to church on Sunday and they run into somebody else driving to church, maybe totally personal and no business involved. But most of the issues that big defendants face, and toxic cases that Jan works on, for example, are going to involve companies that are operating trades or businesses. And so there's no question but that the payments are deductible, payments pursuant to a judgment or payments in settlement. And again, I'm oversimplifying. There are contexts in which there can be fights about whether a payment to the government is really a damage payment or is instead a fine or penalty and therefore non-deductible. There can also be issues for defendants about capitalizing, that is, a payment that relates to, for example, a litigation over title to something, over title to intellectual property, over a destruction of a factory or something that may involve capital assets, and the settlement payment or judgment payment a defendant makes in that context, even if it is a trade or business, may have to be capitalized and not deducted. And as you might expect, I mean, when you capitalize something, essentially it means you're going to deduct it over time, amortize it, depreciate it, essentially. So that's never as good as the immediate tax deduction. Most of the time, you're not even going to hear about these issues because everyone's just going to assume, probably correctly, that everything's deductible. The defendant's going to deduct everything, the lawyer's fees, the payment of the settlement or judgment. In this particular context, though, the reason 468B exists is that defendants were being asked, and it's not, as tax code provisions go, it's not all that old. It only dates to 1986, but the reason